No? Ah, okay. Sorry about this. So good afternoon, everyone, here in the room and online. Thank you for joining us today on this fourth day of the EU AI Week 2025. My name is Isaure de Villenfagne. I'm Legal and Ethics Counsel here in BOSA, specializing in digital matters and in particular AI. Today we will talk about the implementation of the AI Act. So this session will be structured as follows. I will give you some brief reminder on the AI Act and on the process of implementation. Then the FPS economy will then give us an update on the current status of implementation in Belgium and of the next implementing steps to be expected. This keynote will be followed by not only one, but two very interesting panels. Indeed, with the great speakers joining us today and the multiple topics we wanted to address, we have decided to split the discussion in two panels. The first one will focus on legal aspects of the implementation of the AI Act, relating to the objectives of harmonizing the rules on AI and on ensuring high-level protection on health, safety, and fundamental rights. And the second panel will focus on the practical implementation of the AI Act, its impact on companies, the competitivity of the EU, and more largely on innovation. Just for information, we will do a short break between the two panels so that you can just have a glass of water and a 10 minutes break. So thank you. So let's dive in. Today, we are talking about what? About the AI Act. It's a regulation of the European Parliament and of the Council of June 2024, laying down harmonized rules on AI that you all know about. The AI Act is directly applicable to all parties wishing to develop, import, use, deploy within the EU either AI system or general-purpose AI model. Indeed, this regulation has been structured around two poles. So on the one side, the AI systems. These are classified on a risk-based approach, having rules depending on the level of risk assessed. You can see on the slide, on the left-hand side, the pyramid of risk, with AI system considered as practice prohibited on top, followed by AI system qualified as high risk for which the strictest rules apply, AI system with transparency risk, and finally, AI system that entails minimum risk. On the right-hand side, you have all general-purpose AI models that are placed on the market. These are AI models with a general purpose, so these are not specific. They have been deemed as requiring specific safeguards, so for which there are specific requirements, some exception for open source GPI models, and some additional requirements for GPI model with a systemic risk. But when talking about implementation, it's important to mention the timeline in place. As mentioned, a regulation is directly applicable in the legal order of the member states. It means that no national laws is required to have the AI Act enforced in Belgium. However, member states cannot be compliant with all these rules straight away. There are different stages. So it starts with the adoption of a final text. Then this text is published so that everybody knows about it. It's in the official journal of the European Union. 20 days after that, it enters into force. It means that it gains legal effect, but it's not yet applicable. Application is determined by the Act, by provision in the Act. So the regulation usually specifies applicability deadline. So this is a deadline by which member states, but also companies and relevant stakeholders, must be compliant with the AI Act. So, for instance, the AI Act entered into force in August 2024, but most of it is not yet applicable. At the moment, only limited provisions are applicable, notably relating to the prohibited practice that I mentioned earlier and to AI literacy. The time in between the entry into force and the applicability aims to give time to member states and relevant parties to comply with the AI Act. Implementation of the AI Act is thus a long process and still a work in progress. On this note, I give the floor to Jessica Godoy Chaparro and Karen Peel from the FPS Economy. So, Karen Peel, you're a legal expert in the Digital Economy Department of the FPS Economy. You're currently working on coordinating the implementation of the AI Act in Belgium. And besides broad topics such as the national governance structure, you also focus on fundamental rights and on international aspects of AI regulation. You'll be accompanied by Jessica Godoy Chaparro. You're also a legal expert in the Digital Economy Department of the Federal Public Service of the FPS Economy. As part of the team coordinating the AI Act implementation in Belgium, you work on various topics such as the national government structure and AI regulatory sandboxes. You also coordinate the Belgian position in the AI board and manage the Belgian participation in its subgroups. Thank you.
Good afternoon, everybody. My name is Karen. Thank you, Isaure. Thank you, AI for Belgium, for the opportunity to speak here and to present our work a little bit today. I will be giving the first part of the keynote, and then my colleague Jessica will do the second part about the governance. So just a little word, Isaure has already said a lot about this, but why we are here, why the Ministry of Economy. This is because we are the lead administration in Belgium in charge of the AI Act. So we have been following the discussions in the Council working parties before the Belgian presidency, during the Belgian presidency. And since the AI Act has been adopted, we are in charge of coordinating the implementation of the AI Act in Belgium. Besides this, we are also in charge, like Isaure also said, of the AI board and its subgroups, so managing the Belgian input for that. And lastly, we also have our own working group, let's say, where we give information to other government services, or we request input, for example, for a Belgian position. This is called the IEC AI Working Group. This was a brief introduction on our ministry, on what we've been doing and are doing. And now let's dive into the AI Act steps, what has happened already and what still needs to happen. Here you see a list of the most important topics currently of what needs to be done, and the ones that are underlined will come across in this presentation as well. So deadlines that already passed are Article 77, notifying the authorities to the Commission for Fundamental Rights. The prohibited AI practices the ban on prohibited AI has entered into force on the 2nd of February, at the same time as the AI literacy provisions, which we will not discuss further here. Then national governance structure needs to be set up by the 2nd of August. My colleague Jessica will tell you more about that, what we've been doing for that and what is still to come. At the same time, the sanctions need to be in place, and the rules for the GPAI models will come into place as well, which we will also discuss here. And then lastly, my colleague will also say a bit more about the AI regulatory sandbox and about the other provisions which enter into force on the 2nd of August 2026. So let's get started with Article 77, what has happened and what still needs to be done. So currently we have finalized the process of Article 77 because the member states needed to notify the Commission of authorities who will be checking the respect for fundamental rights when high-risk AI systems are being used for Annex 3. The deadline for this was the 2nd of November. As you may know, this was a bit too tight for us, but now it has been resolved, so we have the list online. You can find it on our website and also on the website of the European Commission, who has published an overview of the fundamental rights authorities of all the member states. How did we find out who these authorities are in Belgium? the European Commission has provided us with an interpretive note in which it listed a few examples of categories of companies, institutions that could fall under the scope of this article. And based on this list, we have done a broad consultation in Belgium, federal level, federated level, everywhere to see which institutions could fall in the scope, who met the conditions, and who was also willing to be designated as one of these authorities. And based on all the feedback we got a list of, if I'm not mistaken, 26 authorities who will be checking the respective fundamental rights when high-risk AI systems are being used. As I said, this is now on our website, on the website of the European Commission. And this list can always be modified, so it's never final. It is possible that we identify more authorities who still want to control fundamental rights, or that some authorities withdraw from the list. That is all possible. Even though we didn't have this on the 2nd of November, these authorities can only really start working once the governance structure is set up. So in the summer, that should be possible. And then they will notify the market surveillance authorities when they notice any problems with fundamental rights. So there will be this interplay between these authorities and the market surveillance authorities. Initially only for the high-risk AI systems in Annex 3, but the question is if they can also look broader, for example, fundamental rights violations or potential violations in other high-risk AI systems or broader. That's a question that we're still looking into right now. Here you see an example of some of the authorities that have been notified. This is both at federal level, the level of the regions, the level of the communities. So we've really requested everyone if they saw a role for themselves here. That was Article 77, so currently that is finished. Then Article 5, prohibited AI practices. From the 2nd of February on of this year, it is no longer allowed to use some forms of AI because they are so damaging or have the potential to be so devastating to society. So this is no longer allowed to use these, but some exceptions are allowed if there is a national law allowing this. This is only the case for real-time remote biometric identification. So think of a camera following you on the street and a policeman is watching this from his office. That would still be allowed for law enforcement only if there is a national law allowing this. So what have we done to notify the relevant authorities in Belgium who may be using prohibited AI that this ban was coming and that they could foresee an exception if they wanted to? We've contacted the different ministries, the police, defense, to inform them about this. And currently, a proposition of law allowing for an exception is passing in Parliament, but it has not been adopted yet since the time frame was really short. And we've also had a government in current affairs for a while. So there's a bit of delay on that, but a proposition of law is pending in Parliament. So that's a state on Article 5 currently. And then I will now invite my colleague Jessica on stage to tell you a bit more about the governance and what we've been doing on that. Thank you.
Good afternoon, everyone here and also online. I'm very happy to be here again at this stage now for the European AI Week. I have the pleasure to give you an update on the governance structure in Belgium. So the national authorities competent for enforcing and mostly enforcing the AI Act to be general. Last year, I told the audience that this was under construction, and I must maybe disappoint a little bit because it still is, but we have now more concrete options and have analyzed the possible options a little more deeply. We have integrated this famous pyramid in the presentation because it's important, but Isaure also already told a little bit about them. It's important to recall for which systems we need these authorities. We have three regulated categories in the AI Act, going from unacceptable risks in AI systems, going to limited risk AI systems. The focus of the AI Act, as you all know, are the high-risk AI systems, and we have two types of them in the AI Act. The first category are the AI systems that are a safety component of a product or is itself a product, and have to comply with an ex-ante conformity assessment under the regulations in Annex 1, Section A of the AI Act. As you can see, we have integrated medical devices in the slide, but there are also other sectors like machinery, toy safety, and so on. The second category is this famous Annex 3, where we have an exhaustive list of 8 areas that are considered to be high risk, and all these use cases under these areas that also are considered to be high risk depending on the intended use. For instance, critical infrastructure is one of these areas. So what is in this national governance structure all about? So we have the governance at national level, but also at European level that I will say a word about later. So for the member state level, we have on the one hand, the national notifying authorities, and on the other hand, the market surveillance authorities. So the AI Act states that we need at least one of them, so at least one notifying authority and at least one market surveillance authority. And for these market surveillance authorities, if there are several of them, we need one SPOC, which is the single point of contact. For the national notifying authorities, these are the authorities that will be having powers before the AI system is placed on the market or put into service, and they will be assessing and monitoring the CAPs. These are the conformity assessment bodies, which then after being notified will become notified bodies, MBs. Another important point as well is that the AI Act gives the opportunity to the member states to also designate a national accreditation body next to a national notifying authority, which then will help these authorities with the assessment and the conformity, the monitoring of the conformity. I think that's enough of the legal part of the AI Act. And of course, at EU level, we also have these authorities, the European AI Board, as Karen said, that we're also coordinating within our ministry. We have also the AI Office and the European Commission, that the AI Office within the European Commission as well, which are helping the member states with the governance and with the coherent application of the AI Act. So for Belgium, we have done a lot of things these past couple of months. We have been analyzing the AI Act and seeing what is really necessary. So for the notifying authorities, we have considered that it's only relevant for Annex 1, Section A of the AI Act. As we said, this is the product legislation part, and point 1 of Annex 3, that will be the biometrics area. So we have, after consulting all relevant stakeholders, found out that there is a very good working structure in Belgium of existing notifying authorities. For instance, our own ministry that is competent for machinery, toys, lifts, among others, but also the BIPT, the Belgian Institute for Postal Services and Telecommunications, for radio equipment, and also other authorities for medical devices, for instance. So we have considered these authorities to also become AI Act authorities, and as such broaden their scope of competence and become also competent for the AI Act. But we have encountered some limitations, for instance, expertise and all these resources that are needed under the AI Act, financial but also human resources. And we are looking also at a central AI Act NA. This is all options that are on the table and that will be submitted to the political level as well. And as I said, we can as well designate a national accreditation body. In Belgium, this is BELAC, and we will do a proposal on this as well, because the vast majority of notifying authorities are already working with BELAC. So in order to have coherence and consistent application, we deem it to be necessary as well here. For the market surveillance authorities, it's much broader because the NAs were for the high-risk AI systems only, but market surveillance authorities are competent for all systems carrying a risk, not only high risk. But let's look first at Annex 1, Section A. So here also it's the same structure as for the NAs. We have seen that there is a good working structure of MSAs in Belgium for the product legislations in Annex 1, Section A. So it's actually almost all the same authorities, also our own ministry, the BIPT, but also the Federal Agency for Health Products, for instance. So here as well, we are looking at them to becoming AI Act MSAs, sorry, but also at the central in AI Act MSA, all these abbreviations. So centralization will be key. I think it's already clear now to have like a comprehensive governance framework and to make use of all the expertise already existing in Belgium. So if we look at Annex 3 now, so the other high-risk AI systems going from biometrics to critical infrastructure, essential services, for instance, like financial services, we see that the AI Act have prescribed some specific requirements. For instance, on to be very specific, points 1, 7, 6, 7, and 8, we have this rule in the AI Act that says that the data protection supervisory authorities under the GDPR or the LED should be designated, but there is also another option that says that another authority under similar conditions in Articles 41 until 42 of the LED are also to be considered. So we are looking also at both options at the moment, analyzing them and submit it to the political level as well. For other sectors, for instance, the financial services, there is also this by default rule in the AI Act that says that the authorities already supervising the AI systems that falls under the EU regulation on financial services should also become the competent authorities under the AI Act. So, for instance, the National Bank of Belgium should become also an AI Act MSA. So we're looking at that, if that's possible. But also here on Annex 3, we are looking at the possibility to having a central AI Act MSA. I'm looking at the time here as well, so I will carry on. So for the other two risk categories, prohibited AI and AI with transparency risk, we are also looking at this centralized model to, again, take together all the expertise that is there and make use of all the resources we are having now. So how have we done this? Briefly, we have done a bottom-up consultation of all relevant stakeholders, all the relevant authorities that can be competent or that will be competent. We have organized several meetings, written procedures with all, you can see them there on the slides, with all these authorities. And as a result, we have consolidated all this input into our concept note with all these different implementation options and cooperation mechanisms, and we will submit this to the political level as well, of course, referring to this new coalition agreement on the new federal government that, as you all know at this moment, refers to the BIPT as one of the as an essential authority for coordination, cooperation and control of the AI Act, among other digital acts. So as a next step, again, we will submit this to the political level and align with the regions and communities as well, which may have a competence in Annex 3 above all. To end quickly with these 3 slides on AI regulatory sandboxes, they have to be set up, at least one of it, by the 2nd of August, but I will tell more about this in the second panel. And other provisions in the AI Act, so Karen already tackled some of them, but the rest is to become applicable from the 2nd of August from next year. For instance, the requirements for high-risk AI systems in Annex 3 will become applicable from next year, as well as the transparency requirements. Think of chatbots interacting with humans, which have to comply with transparency requirements. To end, as Karen already mentioned, we are also coordinating for the AI board, and Belgium is being represented by the Minister of Economy at the moment, together with the regions. There are several subgroups that are set up at the moment, and the subgroups that will be important for the national governance will be set up at the second half of this year again. So the market surveillance authorities and the notifying authorities, once the national structures are set up, of course, hopefully for all the member states. So I think I can stop here. Yes, thank you. And if you have any questions of this, don't hesitate to contact us afterwards. Thank you.
Thank you, Jessica. Thank you, Karen, for sharing the status of implementation of the AI Act in Belgium. So I will now call our first panelist to further discuss legal aspects of the implementation of the AI Act. Thierry Boulangé. Yeah, you can come. Thierry Boulangé, you're Deputy Head of Unit AI Regulation and Compliance in the EU AI Office. Your interest in digital technology and their impact has led you to work on a number of initiatives related to digital policy over the last 15 years, including in support to research and innovation. More recently, you were involved in the negotiation of the Council of Europe Convention on AI on behalf of the EU, the coordination of the AI Pact initiative, as well as the monitoring of the ongoing development of the standards that will support the implementation of the AI Act. Then we have Peggy Valcke. You are a full professor ICT law at the Faculty of Law and Criminology at KU Leuven, where you are co-director of the research group CTIP, so Center for IT and IP Law. You're also executive board member of the BIPT, and you served as vice chair of CAI, so the ad hoc committee on AI, and represented Belgium in CAI, the Committee on AI of the Council of Europe. Thank you. Then we have Cédrine Morlière. You are the chairwoman of the Belgian DPA. You are also director of the Authorization and Opinion Service, which provides advice on draft AI-based piece of legislation. The Belgian DPA also took part in discussions and opinions at EDPB level on the interplay between the GDPR and AI technologies. And finally, Nele Roekens, you are legal advisor and AI project lead at UNIA, a Belgian equality body and national human rights institution. You are also chair of the European Network of National Human Rights Institutions Working Group on AI, where you get the collaborative efforts of nearly 50 independent public institutions in matters on AI and emerging technologies. You are also appointed as an independent expert for the Council of Europe's Committee of Experts on Artificial Intelligence, Equality and Discrimination. Thank you to all of you. So we'll start actually with quite a general question. I'm a bit, I cannot really see you, Thierry, but one of the objectives of the AI Act is the harmonization of the rules on AI within the EU. We also hear a lot about the Brussels effect and the impact that EU regulations have on legislation of other countries outside the EU. What can you say about it? Thank you.
thanks for having invited me here this afternoon. Always pleased to engage with stakeholders outside. So, I mean, talking about the objective of the AI Act, I think it's important to remind that the first objective is to address the risk posed by these technologies to health, safety, and fundamental rights. That's where we started from. And that's how this whole adventure started in 2018, when there were questions emerging on the impact of AI. Then, in that context, I mean, discussion did not emerge only at EU level, but as well at national level. So there were initiatives being launched in different member states, and sometimes, I mean, with the possibility to regulate, I mean, to consider rules to be introduced to address these issues which are emerging. And so, in that context, it appeared necessary, I mean, to find a way to address this risk without stifling the innovation potential, and that's how we approach it. So the idea behind the harmonization is, at one end, to address the issues, but without, I mean, while avoiding what could have been a fragmentation of the EU as to the way to introduce such rules. So the way, well, and also more in view of the fact that we are talking about really new technologies with applications which were just being explored, discovered in a way. So the objective of the AI Act was to ensure that in addressing this, we would provide legal certainty, make sure that there would be a uniform approach, and so that we would have a kind of single market for AI, and that would also build on the solid existing product safety legislation framework. So that's how, I mean, I would describe the approach to the objective of the regulation. Then, as far as the famous Brussels effect is concerned, I mean, I would not say that this was an objective per se. But obviously, I mean, as we were amongst the first to regulate, this creates a kind of reference point for discussions, and there were a number of discussions launched in different international fora, I mean, in which we participated, trying also to promote some of the concepts we had in the AI Act. We've had also a number of bilateral exchanges with some partner countries. As far as international fora is concerned, I think it's important to, and maybe other speakers will mention this, but to mention the case of the Council of Europe, where in parallel to the negotiation of the AI Act, I mean, we had the negotiation of what is now the first international treaty addressing risk posed by AI to human rights, rule of law, and democracy. And in that context, I think it's fair to say that we have a number of key concepts of the AI Act approach, which we managed to include in that treaty. So, for example, the risk-based approach, the need to ensure transparency in interactions between AI systems and human beings, the need to ensure transparency of AI-generated content, for example. And remarkably, I would also, I will finish with this, mention that this treaty was to date signed, amongst others, by the US, Canada, the UK, Japan as well. So that would be, how I would describe also the impact of the AI Act at international level.
Thank you. Peggy, maybe you want to intervene on the international tools and other regulation, including the Convention of the Council of Europe on AI?
Of course. Thanks for having me. It's great to be here. Maybe I can continue where Thierry ended, because I also had the privilege to follow the preparation and the negotiation of the Council of Europe Treaty on AI from close by. So, as Thierry already mentioned, it's the first international legally binding instrument on artificial intelligence. Its focus is, unlike the AI Act, not on creating an internal market, but on safeguarding respect for human rights, democracy, and the rule of law throughout the life cycle of AI systems, but in a way that is conducive to innovation. So that was stressed from the beginning, that this framework convention, well, in the beginning we didn't discuss a framework convention because for the first 2-3 years, the direction in which we had to work was not certain. Were we preparing a recommendation? Were we preparing a treaty indeed, a framework convention? So it was only after Kahai's mandate, which ran from 2019 until the end of 21, and Kai had already started, only after a few months the Committee of Ministers gave us an explicit mandate to start negotiating a binding framework convention. So during that whole preparatory process, it was stressed all over, we shouldn't block innovation. Regulation shouldn't hinder innovation, but regulation should guide innovation in the right direction, and in this case, in a way that it respects human rights, democracy, and rule of law. So also, as Thierry already mentioned, it was drafted by many parties. So first of all, the 46 member states of the Council of Europe, but also all of the observer states, Canada, Japan, Mexico, the Holy See, United States, as well as the European Union, and a significant number of non-member states, like Australia, Argentina, Costa Rica, Israel, Peru, Uruguay, and also a lot of, I know, Nele, that there were some criticisms at some point, but also with the involvement of a lot of civil society stakeholders, academics, industry associations. So there was actually broad support at some point for, at 15th of March, almost a year ago, Kai could end its last not the last meeting because we still continue, but that meeting we could end with consensus on a text, which then went to the Committee of Ministers, was approved May 17th, so a few days before I think the Council of Ministers gave the final green light for the AI Act, and then it was opened on the 5th of September in Vilnius for signature. That's why it's known as the Vilnius Convention. And as Thierry already mentioned, by now several countries have already signed, 14 countries, well, 13 countries and one international organization being the European Union. So if you take the European Union as 27 countries, then we are at 40 countries having signed the treaty, including the US, as Thierry mentioned. And I would like to stress that again, because it's important. The United Kingdom, Canada, Japan, Israel, and also a lot of Latin American and African countries are preparing to sign and commit to what the treaty states. I would speak of a Strasbourg effect in this way, rather than the Brussels effect. So now what are the implications of this treaty? Well, unlike the AI Act, the Framework Convention on AI does not apply directly to organizations that develop and use AI systems. It binds the parties to the treaty, which are states, and the states commit to put in place a legal framework that protects human rights, democracy, and rule of law in the area of AI systems. So the first commitment that that parties take upon themselves is to recognize or to put in place this legal framework so that AI systems comply with fundamental principles like transparency, like privacy, dignity and individual autonomy, equality and non-discrimination, accountability and responsibility, reliability and safe innovation. Second commitment is to put in place remedies, procedural rights and safeguards for those who are negatively impacted by AI systems. So this involves an obligation to document relevant information regarding AI systems and their usage. Make sure that this information is sufficient to enable people concerned to challenge decisions that were taken through AI systems, possibility to challenge the use of that system, an effective possibility to lodge a complaint with an appropriate authority. And the third commitment is put in place this risk-based system that Thierry already referred to. So there we have like a mirror system in the convention like we have in the AI Act. So countries commit to put in place a risk assessment system, ensure that this is done in an iterative manner. And one of the things that Kai has been working on lately is a methodology to do so. It's the HEUDERIA methodology, Human Rights, Democracy and Rule of Law Impact Assessment methodology. So a lot of discussion went into the question who should be covered by this AI convention. Only the public sector, because in Europe we are familiar with direct effect of human rights frameworks, where also private actors are under human rights or fundamental rights obligations, but this is not at all a tradition in other parts of the world. So this was a difficult nut to crack, I would say. But in the end, a compromise was struck. So both public and private sector actors fall within the scope of the Framework Convention, but the way that states put in place their framework for private versus public sector can differ. And so you can read the details in the treaty. I can elaborate, but I don't think time allows us to do so. But it's important to keep in mind that private sector doesn't escape the Framework Convention. National security was another difficult nut to crack. Here again, in principle, it falls within the scope of the treaty. It's just that parties to the treaty are not obliged to apply the provisions of the treaty as such to activities that fall in the context of the protection of their national security interests, as long as they comply with fundamental rights, human rights frameworks. And what is out of the scope of the Framework Convention is national defense matters, as well as research and development activities, except when testing is done in real-life situations. So how is this now monitored? Once the treaty will apply, and this treaty will apply from the moment we have 5 ratifications, so signatures do not suffice. Ratifications mean that the legal framework is put in place, but of course, if the EU member states can comply with their commitments under the convention through the AI Act, I think we will have 27 at some point in time. Hopefully. Well, we have
but
to...
we'll come for one.
Okay. Anyway, so when the treaty applies, then a conference of parties will follow up on the how the parties to the convention live up to their commitments. So this is an ongoing process, and there's a lot of diplomacy involved. But it's not that now we have the treaty and the process stops. No, it continues. I hope that...
that's perfect.
And yeah, perhaps just as a final comment, then, of course, international developments were also taken on board. What was happening at the OECD level, UNESCO. So this was emphasized over and over, that we had to align as much as possible with the rest of the world.
And if we follow on that continuation of having the AI Act and international tools, but also national European tools. Mm-hmm. There are other regulations in the EU. I'm thinking about the data package. AI Act is an horizontal regulation. So how does it interact with all these existing legislations?
Yeah, it's sometimes said, I'm going to quote, if I may, the Secretary General of the EDPS at CPDP Data Protection Day. I don't remember exactly the Latin expression, but it meant too many laws, too few or too little justice. Sometimes it said we're over-regulating because we already have all these legal instruments out there that apply to AI systems. We have data protection rules, we have anti-discrimination rules, we have consumer protection rules, and those all continue to apply. But I think, as Thierry explained, what the Commission or what the EU legislator did was to put in place a product safety legislation, not on top or under it, but I would say next to it, to complement what is already out there. And the AI Act, so the prohibited, the high-risk systems, they cover only a small segment of all the AI systems out there. We're talking about 10-15% of the AI systems on the market. And so what is important is that this product safety legislation can intervene or can now oblige developers to test and test again and put safe products on the market and not, if I may become a bit geopolitically, the US mentality is often move fast and break things and then you repair them later. I think a few weeks ago with on your events where we had Ms. Megan Garcia, I think we all understand what dramas can happen if you put AI systems too quickly out of on the market, and this is what the AI Act should prevent. So this testing will be important, and the ability to take things off the market, and that is the bread and butter, I would say, of existing MSAs. In the year that I worked at the BIPT, I've learned more how this works in practice. There are teams that can quickly go even to shops throughout the country. Now you're going to say AI systems are digital, you don't have to go into the shops. Well, for some of the Annex 1 high-risk systems, this is about AI systems being put into physical products. So you may want to have teams throughout the country to take toys and others out of the market. And for the Annex 3 systems, it's also important to be able to be familiar with that system of product safety, how it works, has always worked, and now how the AI Act complements that. And what is special about the AI Act, I think, is this component of fundamental rights protection. So part of the AI Act is based not on Article 114 of the TFEU, but on Article 16. And that's why throughout the AI Act you find references to fundamental rights, data protection legislation. And it's important to make good use of this complementarity, because as Renate Nicolai said at another European AI Week event this week on Tuesday, the BIPT hosted, we need to get the implementation right, and getting the implementation right is to ensure that we do not duplicate what is already out there. Data protection authorities, for instance, have been doing great work in recent years with regard to AI systems, and that shouldn't be duplicated. We need to ensure this complementarity and reinforce each other where we can.
That's very important indeed. And I'm actually going to turn to Cédrine and Nele to have actually a follow-up on this question, but from data protection and privacy, but also from a fundamental rights perspective. And I'll add, because you mentioned it as well, a subsidiary question on the overregulation of the EU legislator. Cédrine?
Thank you. Thank you for inviting us. So I will stress first the strong interactions between the AI Act and the GDPR, to then comment on the strong relationship between the GDPR and AI technologies, and end up with the need for consistency, as you already stressed, Peggy. I will try to use some examples, as Belgian DPAs and European DPAs have lots of use cases where they have already enforced such data protection rights against problematic AI technologies. So first, on the strong interaction between the AI Act and the GDPR, let me first explain that to the extent that personal data are embedded in AI technology, GDPR applies. And it's a quite tricky question to know whether or not there are personal data at hand, because we know data protection authorities or complex it is to qualify data. Is it pseudonymized? Is it anonymized adequately? It is our competence or the competence of the courts to decide on that. Then we also know, thanks to our experience, that it's only after a concrete investigation that you know how an AI technology works and whether concrete data are embedded, personal data are embedded in the technology. One example, I'd like to refer to a recent decision by our litigation chamber. The president of the litigation chamber is here in front of me. And in February this year, they stopped and asked the removal of personal data conversation of students stored within an AI technology, whereas it had been announced that there was no personal data processing at hand. What was it about? It was a noise pollution control product, AI-led, which had been deployed in a student area, and it was supposed not to store personal data, though we found out they had been stored and also sent to the cloud without appropriate encryption. And in this decision, we see that GDPR had just all the tools and the concepts needed to have this technology stopped as appropriate. Also recently, the press asked us our opinion about the recent rollout in shops of cameras deemed intelligent, who would help the shopkeeper to assess whether or not a consumer is a minor. And according to the news article, the press articles, there is no personal data processing at hand. Of course, we have, as Data Protection Authority, won't take any view on this use case as long as there is no investigation. The only message I want to bring is whether or not there is personal data, whether or not there is biometric data in the sense of the AI Act or the GDPR. It is only possible to know that after an investigation of such technology. So therefore, it's very welcome that the AI Act foresees a strong cooperation between all competent authorities and a strong involvement of data protection authorities in sandboxes, for instance. And we need to be associated in the supervision of AI systems since as soon as personal data are concerned, we will be competent to take the right measures. As a second message, I would like to stress that the AI Act is complementary to the GDPR. It is not a lex specialis, and even if the AI Act applies to some technologies, general GDPR principles also applies. Take, for instance, an AI technology which would fall only under the AI Act. General principles on transfers of data would apply as well. This is why at least a strong cooperation between all supervisory authorities is needed, and it's an open secret that DPAs at a European level, at an EDPB level, see themselves as very well equipped to have a strong role in the enforcement and the control of AI technologies. So now I would like to dive a bit on the interaction between the GDPR and the AI technology. This interaction is quite obvious since the Belgian and European data protection authorities have been among the first authorities to take enforcement actions against problematic AI technologies. And this is true as well before and after the entry into force of the GDPR, the partial entry into force in August last year. I'd like to quote a recent decision by the French authority stopping a web scraping company from collecting confidential data from LinkedIn beyond any reasonable expectation of the data subject. We can also refer to enforcement cases before the GDPR, bans, temporary bans against chatbots, against generative AI for lack of appropriate legal basis. The positive message I would like to bring is that the GDPR can offer a suitable legal basis for AI technologies. This stems also from amongst others, a decision of our litigation chamber dating March last year, where it anticipated the possibility to invoke one's legitimate interest to make an algorithmic model. And the solution which was found there was to make a clear distinction between the training of the data and the further use of the data. And for the training of the data, legitimate interest under GDPR was a possible legal basis, with as several conditions, amongst others, applying suitable technological measures such as anonymization, pseudonymization. So back to the AI Act, which is also the reason why we are sitting here, of course. The AI Act is, of course, very important and offers additional a priori supplementary controls, clarifies prohibited areas. And as already mentioned, it replicates or is inspired by GDPR principles. And as last message, I would like to stress that consistency is needed. I think Nele will discuss about the need of consistency between GDPR and ACT as regards FRIA and as regards the discrimination and biases. And I would like just to have one example based on the right to explainability and human control. What does that mean for the citizen? We have a very recent use case from the Court of Justice applying Article 22 of the GDPR to the need to the right to explainability. It was a case where a citizen was barred from subscribing to a monthly mobile phone subscription of 10 euros due to a negative AI-led credit scoring with, and that was the problem, no possibility to get explanation, intelligible explanation on this. And the Court of Justice decided on 27 February this year, the case done in Bradstreet, that the GDPR Article 22 includes a right to explanation in such instances. Just for the legal experts among us, this closes a long discussions whether or not the GDPR already offered a right to explainability in such instances. The conclusion is no, yes, and this somehow minimizes the impact of the AI Act in this context, but it is noteworthy that there is also an ongoing request for a preliminary ruling based on the right of explainability under the AI Act, so Article 86, which echoes the explainability right under the GDPR, and it also concerns somehow a similar use case. It concerns the right to explainability for in the context of a telecom invoice. So consistency will be needed. That would be my last message. And it follows from it that the application and enforcement of, for instance, data subjects' rights might be quite complex if the authorities which are competent are too different, or at least if there is no appropriate cooperation mechanism in place. This is the message that I wanted to convey, but not only me, but also my board of directors, one of which is sitting here with me. So thank you very much.
Thank you, Cédrine. Nele, do you want to add any comments, and especially from a fundamental rights perspective?
Yes, definitely. Thank you, Isaure, for also for inviting us. And it's an honor to be here at AI for Belgium, but also to be able to complement already these very comprehensive explanations of the existing framework. So I think the main message and the bottom line is, if you're asking me what is the role from other existing fundamental rights regulations, so whether we're talking of the EU Charter of Fundamental Rights, the European Convention on Human Rights, the United Nations Convention on the Rights for Persons with Disabilities, but also national legislation on, for example, non-discrimination and equality, they all apply regardless of the application of the AI Act or not. So in both instances, at the same time, they will be applicable. So I think for now, it's maybe interesting to explain a little bit more how this fundamental rights approach is enshrined in the EU AI Act, as already explained by Thierry and Peggy. So the aim of the AI Act is the protection of safety, health, and fundamental rights, which is quite remarkable in a product safety regulation. And what we can see is that this fundamental rights attention has a knock-on effect throughout the text in different chapters. So within the risk classification, when we decide, for example, that the use of a certain AI system is prohibited, this is amongst other reasons because of the risk it presents to fundamental rights. So, for example, the example that was mentioned before by Faute Economie, real-time remote biometric identification poses a risk to freedom of assembly and non-discrimination. When we look at the high risk, for example, AI used in selection processes, in recruitment, then there might be a risk to privacy, is explained in the recitals, as well as non-discrimination. So this is how you see that the fundamental rights are enshrined in the reasons for the risk classification. But it's important to underline that this risk classification is a result of, it's actually the result of a political compromise at a given moment. And depending on the risk category, it can be updated via different ways, but it does not necessarily reflect the actual risk it poses to human rights or non-discrimination. So it's very important to underline that the other existing fundamental rights instruments still apply. Also in the high risk, in the requirements for the high risk systems, we can see this attention to human rights, and the most important article in that sense is the introduction in Article 27 of the Fundamental Rights Impact Assessment. Admittedly, in certain conditions, we will not delve into that, but that is an important element, and we can come back to that in the second round, and also how it relates to the data protection impact assessment that already exists under the GDPR. But this brings me to the next part, where we can clearly see the fundamental rights approach enshrined in the structure and architecture of the AI Act is actually in the governance structure. And I'm very happy that Karen already explained it in detail, but this is very important to look at this Article 7070 of the EU AI Act. So it's basically designating and explaining a little bit the powers of existing authorities protecting fundamental rights. Okay, it was mentioned there are 26, but what does it actually mean and why was it necessary? So let's recall a little bit because of the characteristics of the AI and the way it is used. The opacity, limited transparency, deployed on mass scale. All these reasons, it might be difficult to, as a civilian, to be aware that AI systems are used and that it negatively affects you. And if you're aware of that, the effort it requires in terms of financial means, time, mental capacity to address it, it can be quite challenging. And also for the existing authorities that are already in place, sometimes it's difficult to assess or the necessary information you need to ascertain whether or not there is a human rights violation. So simply put, this Article 7070 gives to the authorities that are already existing, that have a mandate to protect fundamental rights, so in my case of UNIA, combating discrimination and promoting equality, it gives us the tools to request the necessary information and to access the information to ascertain whether or not there has been discrimination. There is also the possibility to trigger an investigation. And also the market surveillance authorities will need to inform these Article 7070s in certain situations, but broadly speaking, we can say when there are risks to fundamental rights identified or serious incidents. And at UNIA, we're already preparing for this role because, of course, it requires a certain expertise and capacity, and we do this via a technical support instrument. This is funding provided by the European Commission, the Reform Unit, and it's a multi-country project that we do, amongst others, with equality bodies from Finland and Portugal, etc. So, but to reply to the second part of the question, is there overregulation? From our point of view, from where we are standing, if you do not take into account fundamental rights protection from the outset and you allocate the necessary means, also financial means, it might eventually compromise the trustworthiness of your product and could in turn result in less take-up of a certain technology, in addition to the reputational harm of your business. So, and if we think, is it too much, the AI Act, if you control EVIT and you do innovation and non-discrimination, you will see an equal amount of matches. So it seems quite balanced to me.
Thank you, Nele. Now we know that the AI Act has been adopted. It's a lengthy text. However, there are many references to other documents, such as implementing guidelines, code of practice. So yeah, the work doesn't seem to be finished yet. Thierry, maybe can you give us some insight about this?
Yes, I can. So I mean, these days, whenever I have the occasion to speak about what we are doing now, that the AI Act marathon is completed, because I mean this adventure. So as I said earlier, started in 2018. It was quite intense, long. I mean, intense. at least. And but it did not stop. I mean, the adoption in June last year just marked the beginning of a new phase, which somehow is not less intense than the previous one. Some of the introduction presentations, I mean, also Nele's intervention somehow already pointed to all the important work which is ongoing in order to enable the actual implementation of the regulation. And here it's important so to remind that there will be actually a progressive entry into application of the regulation between February this year for the very first measures like the prohibitions or the provision on AI literacy until August 2027 for the entry into application of the obligation for what concerns high-risk AI systems. I mean, use the safety components of regulated products. So part of all the efforts aimed at fostering a smooth implementation, preparation of that implementation, consists indeed in developing a number of elements, documents, which are meant to further clarify the provisions of the AI Act, provide also concrete examples, I mean, more detailed insights into the Commission's interpretation of the legal provisions. And indeed, there is quite a list of such elements. So we already had, I mean, for those who are following closely this work, beginning of February, we had the two first set of guidelines issued on the definition of AI systems and on prohibitions. Before the start of the panel, we were discussing, I mean, some feedback on the fact, isn't it too much? Doesn't it make it too complex? But I mean, the idea is there, if I take the case of the prohibitions, that this is meant for practitioners, I mean, for people on the ground, and so that they can find in this guidance what specifically concerns their specific case. So this is how this should be understood, not as something which would further complexify the regulation. So we have these guidelines. But in addition to this, there are also other elements, as I said, which are meant to support, I mean, further elaborate on the regulation. And here I would start by mentioning the case of technical standards. I mean, we say the regulation for what concerns, in particular, high-risk AI systems builds on the product safety legislation, in particular the so-called new legislative framework approach, meaning that we have the essential requirements in the regulation, but in order to make sure that they are future-proof, that they take into account the state of the art, I mean, the details are left to standardization bodies, and it's an option actually, it's not mandatory, but standardization bodies are asked to work on further elaborating these requirements in technical standards, which will help, again, people on the ground, practitioners and providers of AI systems understand better, figuring out better how they can concretely address these requirements in the way they develop their product, in the way their product should be used. So this is very important work, which is ongoing. Actually, in view of the importance, the key role of these standards, because I mean they will have they will give, I mean, this will give the possibility for providers which will rely on them to get presumption of conformity with the requirements of the AI Act. There were even a number of judgments from the Court of Justice of the EU. I mean, somehow, well, not somehow, saying that these standards can be considered as part of EU law and that they play a key role in this overall structure. So this, in view of this importance, we did not wait until the adoption of the regulation to get this work started. We engaged with standardization bodies already very early on. I mean, after the issuance of the Commission proposal for the AI Act, we issued even a formal mandate, a formal standardization request as early as May 2023. So again, before the actual adoption. Now we are in the process of amending this request to take into account the formal adoption of the AI Act. So this very important work, I mean, this request was addressed to Nele, so one of the recognized European standardization organizations. We are following this work very closely. I mean, colleagues are participating to not to all, but I mean to a number of the meetings of the different working groups which have been established by Nele to work on this. I mean, more concretely, we are talking about specifying at technical level how to address issues such as human oversight, accuracy of AI systems, their robustness, cybersecurity aspects, the data quality and data governance, the risk management framework, and also the overall quality management system. So this is very challenging work which is ongoing and which we are following quite closely. For what concerns the obligations applying to general purpose AI models, I mean, this will enter into application already in August this year. And this was not part of the, as you well know, not part of the initial proposal from the Commission. So there, we had to find a solution to provide similar guidance, but I mean, without the possibility to use standards, because I mean, on average, it takes, I mean, when everything goes well, 3 years to develop standards. I mean, very often more. We don't have that time, and that's how, I mean, came the idea to develop this code of practice, which is subject to very intense work these days. I mean, for which there was a third draft released recently, with the plan to finalize this work in May. And then, I mean, later, I mean, at some point, there will be a need to also work on standards to address this part of the regulation, and probably building on this work which has been carried out with the code of practice. In addition to this, I mean, well, let's say in all these things, what is important in the way we approach the preparation of the implementation of the regulation is engaging with stakeholders. I mean, taking into account feedback. I mean, on concrete issues being faced with regards to the preparation of the implementation of the regulation, and this is one of the reasons for which we launched the AI Pact initiative already. Depending which time date you consider, let's say last year. So we currently have a network of more than 2,000 organizations of different types, so companies, small companies, large companies, I mean, providers of AI solutions, users of such solutions. We also have public authorities, NGOs involved in this discussion. And there, the idea is really to create a kind of platform to exchange of all matters relating to the implementation of the preparation of the implementation of the regulation, without interfering in the specific processes which are being launched to develop the different elements I was mentioning before. We have also engaged with a restricted set of companies which have expressed willingness to start taking measures in line with the provision of the regulation. So this is also still under the AI Pact umbrella. So I mean, a number of companies have accepted to sign pledges, so confirming their willingness to take measures which would correspond to implementing some requirements of the AI Act. And we would like to use this as well as a way to inspire the discussion on how to implement concretely the regulation. So this is part of all the work ongoing at the moment to, as I said before, make sure that from the legal text we have something which is very clear to everybody for the implementation between now and August 2027.
Thank you, Thierry. From a privacy and data protection point of view, Cédrine, maybe do you want to add something to this, or are there aspects that needs to be highlighted or to improve? Do you have examples, maybe? Wait a minute, I think your mic is not on. Thank you. I think you can try.
As regards, yes, it works.
Yes, thank you.
Yes. As regards improvements, we are very happy and very keen to see the development of sandboxes. I think it's important that all competent parties can accompany innovation. And second, the positive message I would like to have to conclude is that in cases there would be any loopholes, the GDPR will be there to prevent us from falling into these loopholes, because it's a tech-neutral and catch-all legislation. And thanks to GDPR, we can try and avoid intricate discussions on competence, as the decision of the litigation chamber shown. It is possible with GDPR to enforce AI-led technology if problematic, though we also want the most consistent framework as possible. That would be my message.
That's a good point, though. Luckily, the GDPR is here as well, in interest of having maybe a horizontal regulation. And Nele, from the fundamental rights perspective, do you want to add anything?
Should we keep it very short?
Yeah, the time is ticking, but you still have a bit of time.
Okay.
Don't worry.
So I completely agree, of course, with what Cédrine just said. If I'm thinking also about some of the concerns and use cases, and also a positive example that we could give, I'm thinking one concern that has been widely shared by human rights specialists, but also non-discrimination experts, is actually a concern that, okay, ex post in the enforcement structure, there is due attention for fundamental rights, but how do we ensure fundamental rights expertise also more ex ante? And there are two reasons that led to this concern, and this is first the architecture of the structure, and as Thierry just explained, the presumption of conformity when there is compliance with the European standards. That on the one hand, and secondly, more pragmatic efficiency reasons and the current discussions that we are hearing about reduction of the administrative burden and cutting what is considered to be red tape. So this leads us to a little bit to being concerned that when implementing, for example, the requirements of the AI Act, that companies might rely either on coders, then when it's for the assessment of the acceptable level of residual risk, or more on the DPOs when it comes down to the data protection impact assessment. And whilst both expertises are crucial and extremely relevant, when we want to assess the impact on fundamental rights and protect against fundamental rights violations, it's absolutely key and essential to have people with fundamental rights expertise that is not limited to data protection and privacy. So this is one concern that we have, but we see a lot of opportunities there also with the close cooperation between different Article 7070 authorities and between the market surveillance authorities and the 7070. So we are hopeful that we can work on that. But then another concern that we would like to raise that is also that will not surprise you, is actually the loophole that is introduced in Article 6. So Article 6 provides for the possibility to circumvent the applicability of the requirements for high-risk systems, even if you fall under Annex 3. And this evidently raises some concern, and for that I do not yet have a solution, but I would like to warmly encourage the Commission, the AI Office for the Economy, the future national contact points to be very aware of that real risk and to consider installing robust mechanisms for the self-assessment of the opt-out. But then let me end with a positive note. So I'm very happy that Peggy already discussed the Huderia, the fundamental rights impact assessment developed by the Council of Europe. And there is actually a best practice that we would also like to introduce in the EU AI Act. You might know that the AI Office is currently developing a template questionnaire for the fundamental rights impact assessment. And we think it could be extremely useful to include the zero question. The zero question, it might be a new term for you. I can recommend you to have a look at the Council of Europe methodology. It boils down to when you're developing or you want to deploy an AI system, that you think very critically whether this AI system is the appropriate tool. and that you also consider if there are non-automated options that have lesser risk to fundamental rights and other important considerations. And it's not something super new and impossible I'm proposing. If you have a look, there are already some member states that are doing this. The city of Rotterdam in the Netherlands has decided not to deploy a fraud detection system that was already developed, merely because there were doubts whether it could achieve the required level of transparency and legality. So that is a very inspiring best practice, and I think I would like to end on that note. Thank you.
Thank you, Nele. And so we've talked about lots of different topics related to the legal aspects of the implementation of the AI Act. Maybe, Thierry, do you have a concluding message?
Yes, very quickly, just mention briefly, there will be as well guidelines on the implementation of Article 6 and this filter provision. Yes, these days, we see a lot of, we see a narrative emerging about over-regulation, and an opposition as well between regulation and innovation. So maybe my last words would be to also recall the approach we've taken with the regulation, the fact that by itself it is meant actually to be supportive to the innovation ecosystem. So support the innovation by providing legal certainty on how to approach the rules imposed on AI. Supportive to innovation by ensuring that there are uniform rules across the whole EU. Supportive to innovation as well by taking a very targeted, a risk-based and very targeted approach, so regulating as needed only where it is needed. And indeed, the estimate was that most of AI systems would actually be exempted from any obligation. It supports as well innovation by the mechanisms which are put in place for the implementation. Be it, for example, the fact that we rely on the product safety legislation framework, the fact that we rely as well on technical standards. It is supportive to innovation as well with some of the elements it includes. And here I will mention the regulatory sandboxes or what concerns real world testing. And in addition to that, and now just taking a broader perspective, and here again to address some of the questions which are being raised on this matter, I would recall that next to this, at EU level, there are a lot of initiatives, and there's a lot of effort ongoing in order to support directly the innovation ecosystem, to support the emergence, the development of and the adoption of AI technologies. And you saw there were a lot was done over the last years, and then there are also there were also very significant recent announcements, and probably more to come. And and in that context, Horizon Europe and Digital Europe are key instruments which are being mobilized to support innovation. And I will stop here for the sake of time.
Yes, exactly. Thank you. Thank you very much for this conclusion, which is actually a very nice transition to the second panel, where we will be talking about the impact on companies and on innovation in general. However, I propose that we take a 5-minute, 10 minutes break, 10 minutes, so we should start back at 35. Thank you very much.
Thank you.
Dank je.
No questions
Oei,
from
zijn wij
the
nog
audience?
aan? Ja.
Ik heb niet over chatbots gesproken.
Nee,
maar-
wat was goed, hè?
Die vergat
Ja,
daarna, ja.
ik was een beetje verbaasd, want de tweede interventie was op. Dus ik had verwacht dat je mij ging
Ja,
zeggen.
ja,
Dus.
ja.
Oké.
Ik dacht
Ja.
dat we reeds op waren met de tijd.
Oké.
Dus voilà, maar dat is niet erg.
here. 10 secondes. Ok.
Il faut que ça soit fait. One, two. Hello, hello, everybody. Please take your seats. We're going live in 1 minute again. Five, four, three, two.
So welcome back for this second part of this session on the practical implementation of the AI Act. So now we'll talk about companies, innovation, and what is the impact for companies. So I'm here with Jessica from the FPS Economy that we already heard today. We then have Martin Canter. Martin, you're head of the Smart Region Hub of at Fari Institute, partnership from the ULB and VUB. Your team focuses on supporting the academic, the public and private sectors in developing and implementing AI solutions through multiple actions, developing and supporting strategic thinking and policy making, linking with domain experts from the academia and EU ecosystem, and more specifically on domains related to digital twins and AI regulatory sandboxes. We then have Jelle Hoedemaekers. You are a Belgian expert in the field of digital policy with a specific focus on artificial intelligence, data and cloud computing. You are currently working as an expert data economy at Agoya, the industry federation for Belgium technology industry, where you are responsible for ensuring that actions at EU, federal and regional levels suit the needs of Agoya members. You work on policy topics related to AI regulation, data strategy and standardization. Within AI for Belgium, you are also the co-chair of the Ethics and Law Working Group. Thank you all for joining me today. So I'll start with quite general question for you, Jessica. So we talked about innovation measures and support for companies, but what are these measures in the AI Act?
Yes, thank you for this question.
I don't think your mic is on. Sorry about that. Just a minute.
Sorry. Hello? Do you want the mic?
Just give the mic.
No, it's good. Is it good? I think it's good, yes. Okay, again, thank you for the question, Isaure. Indeed, within the Federal Public Service economy, we have analyzed the AI Act very deeply, and of course also the measures for innovation. So I'm happy to share some of these measures very briefly, because we have other experts on the field here who are certainly eager to speak as well. So maybe a first measure is that the member states should have a dedicated communication channel for SMEs. That's one of the measures in the AI Act. So this channel is for all communications purposes. It has to be tailored to SMEs. It has to have the aim to give guidance to SMEs. Probably also a platform where you can ask questions on the implementation of the AI Act. So that's a first measure, and we have seen that some member states have already implemented this. For instance, Austria, who has a AI service desk, but this is, as we have heard, more general on AI questions, AI technologies. But for the AI Act, we need like a really tailored communication channel for SMEs, and later I will elaborate more on what we are doing at a Federal Public Service economy. So another measure that is important is simplification. We have also seen the new agenda of the Commission. So we need simplification at all levels, so also on documentation and targeted training. We have heard already the obligation of AI literacy, for instance. So this is another measure that all member states will have to comply with, and all with the aim of course, safeguarding a coherent application of the AI Act and making it easy to understand for all companies, and in particular for SMEs. Another measure that I can mention is, in general, the principle of proportionality. The obligations in the AI Act should be proportionate to the modal providers. For instance, we have seen that SMEs, the type of model providers, for instance, SMEs have been taken into account in the code of practice for GPI model providers. If this has been done in a proper way, I cannot say at the moment, but they are taking this into account from what I have heard. And of course, one of the main measures are the AI regulatory sandboxes. I already touched upon this in my presentation before. So all member states will have to set up at least one AI regulatory sandbox at national level. This can be also done, for instance, together with other member states, and also regional ones can be set up, but we have to have at least one at national level. If we look at what are regulatory sandboxes, I can tell you the definition in the AI Act. We have some elements here. So it's a controlled framework set up by a competent authority. So again, we need a competent authority here. I talked before about the national competent authorities, which is more limited to the notifying authorities and the market surveillance authorities. But for this, we can look broader, and we have to still designate one, or maybe a better wording is appoint one that will be responsible for the sandboxes. I'm looking also at Cédrine, who was here in the panel before, and of course DPAs will be also involved in these sandboxes when the processing of personal data is being carried out in the sandbox. So this framework is for providers, prospective providers of innovative AI systems, where they can not only develop and train these systems, but also validate and test them. So all of this will be done based on a sandbox plan and within a limited time and under regulatory supervision. So these are all the elements in the AI Act definition. So it's all very sec to say it like that. It's all law, and we still are awaiting the implementing act from the Commission to operationalize these elements. So for SMEs especially, we have a special treatment in these sandboxes. For instance, they will have priority access to it and also be free of charge. So in terms of cost, administrative costs, they also look at that. So to end, maybe, so on these sandboxes, what we have done at the FPS economy is that we have commissioned a study actually to analyze what is the best way to set one sandbox in Belgium in general. So this study is being conducted by the Valcke Institute actually, so I think Martin will be happy to elaborate further. What I can say is that the main goal is to analyze and prepare some legal basis to have a transversal sandbox in which we can also include the AI sandbox under the AI Act. But this is all under construction again and being analyzed. So I think I can stop here and Martin will tell you more about it.
Exactly. I was about to ask you, Martin, what are regulatory sandboxes? Is it new or does it exist in other sectors? Do you have examples? How can it help companies and how is it implemented at Belgian level?
Right. Thank you very much for the invitation, and thank you already for the first introduction, which basically makes part of my answer already moved. But basically, well, sandboxes themselves are new and not new in concept. They're basically a side effect of the 2008 financial crisis, where in the UK they came up with the idea of sandboxes because they realized that if you leave, especially well in the technological sector, innovation go too fast without control or without monitoring, it can actually have damaging effects. So they thought, okay, why not give an environment, especially to the fintech sector, to innovate and to basically develop new products and put them on the market, but still while under supervision, some kind of environment in which things can be tested so that you can learn from what's going to happen and potentially also then prevent potential side effects of your product. So that was the initial idea. Since then, I think that you can easily find it online. Sandboxes have been flourishing around the world in many different topics. Most of the time, they're rather verticals. So really specifically on one domain, it can be financial sector, it can be agri-food sector, it can be healthcare, it can be energy also. A lot of different stuff can happen. Different ways of implementing sandboxes. So you've got here, well, for us in the AI Act, the AI regulatory sandboxes. But you can have sandboxes, you can have regulation, regulatory sandboxes, and then for specific domains also. They can be technical, non-technical. It can be just about regulatory learning. It can be about testing the products. So a lot of different ways to actually do that. So that's basically, well, in a nutshell, what sandboxes are. In some extent, you can also compare them a little bit to the notion of low regulation zone. That's also something that exists a little bit in Flanders, but not completely well in broad perspective. And in Belgium, they don't it's not really a concept that's being used a lot. Other countries are much more advanced in having already sandboxes in different fields. Like in Germany or in France, for instance, they're a bit more experimented, historically speaking, on the concept of sandbox. So with regards then to what needs to be done for us, especially well in the AI Act and then basically within Belgium, the first thing that we need to know is that the actual deadline to be able to have that to comply basically with the AI Act is August 2026. So that's why now the study is being performed to help then for the economy provide a bit of guidelines on how to do that and learn basically from the other experiments. We can mention, for example, the Spanish pilot project on sandboxes that they've put in place to learn basically with the European Commission how it can work. Other countries are also looking at it and actually will already either running their own pilot project or at least designing that, like Sweden, Netherlands, Norway also to some extent, and so on. So a lot of countries are basically exploring that at the same time, providing feedback through conversation directly with the AI office and so on. So the concept itself is still being refined with the AI office, and everybody's learning at the same time on what works, what doesn't work, and let's try to make it happen. With regards to Belgium, then I think basically it's making good progress. Not going too fast, but not going too slow either. We'll see how it goes afterwards. I don't want you to make any promises. Yep. So basically, also the last point that's quite important to know exactly what a sandbox is. So apart from the concept itself that was defined already by Jessica, from the notions that are written in the AI Act, we need also to remember exactly what the sandbox stands for. And basically, well, here mentioned for us in the AI Act is to provide first legal certainty, so to be able to basically explore legal concepts basically and make sure that there's an alignment. We've seen from past experiments or past sandboxes that they've been running where basically companies come and have a specific legal interpretation of a concept that's a little bit vague, and the regulator has a different interpretation. And so most of the time the conversation goes on, okay, what's actually the right way to either understand that or implement it, and it's mainly about having a conversation between the companies and the regulators in that controlled environment to come to a common conclusion of what needs to be done and how does it need to be done. So it's not always so much about let's just apply the regulation for a use case, but rather understand commonly what needs to be done and then share that with other parties, basically stakeholders, other companies, or other to call that regulators basically that need to apply that. So it's also about the sharing of best practices. The concept itself of sandbox is also not really to only regulate, but also to foster innovation. So let's say that you've got a completely new product and you want to test it, and you want still it to be safe. It's a good way to actually come into the sandbox to get accompanied in your process, to get a bit of support to do it properly, and then to actually build on that evidence-based learning. So that's really what a sandbox is and what it's used for.
Well, thank you for this explanation. So we talk about measures to support innovation, but are there other tools existing in the AI Act? I'm thinking about conformity tools for to help companies to comply with the AI Act. Jelle, can you tell us a bit more about this?
Are they existing? Not yet. Are they coming? Yes. But maybe before we go to the conformity assessment, I maybe would like to give my point of view a bit of where we are with the AI Act now. Because on a daily basis, what we at Agoria do is help our members as well to implement regulations, to give them advice on how to work with this, for example. And specifically in the last months, we're getting a lot of questions on the AI Act. They've heard about it somewhere. They think, we will need to do something. But conformity, that's something very far off. Where we basically are now is these companies have still not really an idea, okay, am I now using AI or not? Is this specific tool that I'm using or developing considered AI under the AI Act? Which is basically step one, which you will need to decide upon. So let's say the maturity is still quite low, so there's some work to be done. What we also see, and this is a bit also referring to the past panel, is that what we need is clarity. And there we see that there's still also quite a lot of work to be done. For example, the Commission issued guidelines on the definition, but even with these guidelines, it's still quite complex to interpret it. What we see as well is within the AI Act, they thought about a certain value chain. For example, you have a general purpose AI model, which can then be used to make maybe a high-risk system, and then you have a deployer. And if we look towards the reality of how AI tools are being developed and implemented, there's a lot of divergence. So there are a lot of things to figure out still. However, certain companies are already past that and looking towards what can I do now to comply. And there also, it's a bit tricky still, because let's take the example of logging. So there are logging requirements for high-risk AI systems. And what we see there is that already as a best practice, companies are doing that. However, they do that according to their way, something they've developed based on something. This doesn't necessarily mean that this will be enough for the AI Act. what we will need there, and the reference was already made, is the harmonized standards. So the harmonized standards will play a key role in the future to comply to the AI Act. And these are, as mentioned, at the moment under development. The tricky thing is that there will be delays, and I have to say as well, it's very much appreciated, the work which the Commission is doing at the moment in helping accelerate this development, but there remain certain challenges. One is the fact that we are trying to standardize a technology which is still constantly moving and in flux. Normally, standard development happens after you reach a sort of consolidation, and then upon this you can build standards. So now we're trying to, upon a moving technology, fix standards, which is a really tricky thing to do. Another thing, and that is a warm invitation to the people here and online as well, is that for certain documents, experts are missing to actually write and develop these documents, meaning that there's a lot of things which need to be written, and stakeholders from industry, academia are really needed to set these standards. So a warm ask to everyone, if you maybe have a certain expertise, want to know more about the standardization development, come and find me. I can help you to see if it's something we could collaborate on. Maybe, and to end this one, it's not that it's not fully clear that we're already not seeing a direction or giving companies something to go on. And something I want to reference here is there's already an international standard, the ISO 42001, which, let's say, will not be a standard which assures full compliance, but what we advise specifically for companies who say we want to go towards this road, we say already maybe start looking towards this one as a first step to see what this would mean for you, how you would implement it. I see you're not agreeing, but as a first guidance, this is a bit at the moment what we say.
Thank you, Jelle. Martin, do you want to complement or add something on this?
Yes, well, basically, I totally agree with Jelle that for the moment, and while performing basically that study on AI sandboxes and how to implement them in Belgium, the main takeaway that we've got for companies is they don't really know what to do and they need actually help to do it properly. So that's one of the main points for the moment that we see through different actions and through different projects also on the European level where we're involved, and also talking basically with the other stakeholders in Europe. So everybody's basically struggling with the same issues. We're trying also to put those tools in place to try to, well, for each entry point where companies might actually come to support them. And this does not only concern, by the way, the companies, but also the public administration themselves have quite a bit of a struggle to actually achieve that properly. So there, amongst the tools, we can, for example, mention the EDIs that are really supporting SMEs and startups to actually adopt the technologies, but also then the TIFs themselves that are also providing the services and potentially on the long-term compliance services to support companies to implement them. So tools are being put in place, the pain points have been identified, but it will take a bit of time to get there.
Thank you. Maybe now a word about competitivity. So what are the opportunities and challenges of the EU and eventually of non-EU companies to comply with the AI Act? Jelle?
Well, coming from industry, you might assume that we're fully against the AI Act, but this is really not the case. So talking to companies, they in general support the ID. They see that there are certain risks which are coming with the technology, so there's no broad opposition to, let's say, a regulation on AI. Next to that, we feel this is something which correctly has been addressed at the European level, because the assumption is if there wouldn't have been an EU AI Act, every country would have developed their own thing, and then, yeah, we would have also these problems of the European market. I referenced already certain challenges, specifically relating to the scope, but what you see as well is a lot of questions around the fact is something high risk or not. So there are still a lot of open questions, and that's also where we feel that a strong national AI coordinator will play a very important role in the future. So there, what we hope is that quite soon we can progress on this to, let's say, have a body which can give us specific clarity and which can really help us towards compliance. Now, you make the reference to non-EU. Of course, our focus is specifically on Belgium. But of course, the AI Act states as well that if a provider from outside the EU puts something on the market in Europe, of course, it will need to comply with the AI Act as well. But there I want to make a bit of a parallel of something that we see. As mentioned before, the AI Act is based on the new legislative framework, so product regulation. And what we know there is, for example, the CE marking, meaning that as a company, if you claim conformance, you can affix a CE marking to your product. The reality is that if we import physical goods, like for a Temu or something, they will just print a CE marking, meaning that they just claim conformance, but in reality, they just say they're conformant, while actually they're not. So this is maybe a concern that we have as well, that companies in Belgium are doing a lot of effort in complying to the AI Act and make sure that products are compliant. But actors outside of the EU will just claim compliance and put their products here on the market, which will, again, put the companies at a competitive advantage. So something to really take care about in the future as well.
Okay, and for you, Martin, is the AI Act and its regulation really bad for competitivity? It's a bit of a follow-up of Jelle's question.
Yeah, no, indeed. It's actually a good point that Thierry is making, but at the same time, well, from the regulatory sandbox perspective, it's also something that we've seen evolve over time. The more AI evolves and the more it gets refined, the more then potential issues are actually showing up. And I think that everybody has heard about different scandals from Cambridge Analytica to some chats becoming aggressive and so on online. The main problem is that to actually regulate properly, you need usually what people call evidence or evidence-based learning. And the more we see that companies are actually struggling with potential evolution of the product, basically not controlling exactly what happens, the more they tend to actually retain evidence basically to themselves, or even sometimes say, okay, don't write it out concretely, but just speak about it already inside your company, so that if something happens afterwards, or sometimes they even say when something happens in the future, we cannot become liable, or we cannot really become like too responsible for knowing that it was going to happen, and we still took the risk. So there I just want to actually show the role of the regulatory sandbox itself, which basically allows the regulators to also say we want to explore something specific, to be able to collect evidence so that we can actually regulate something properly. And I think that making the parallel also with, let's say, the tobacco industry in the past, or global warming, or the ozone layer, and so on, every time we wait too long to actually take action, something that we know is potentially an issue, if you wait for something bad to happen before you start collecting evidence and regulating, then it's already too late. And here, potentially with AI, the idea is not to over-regulate, but rather with the regulatory sandboxes to be able to collect the evidence so that we can regulate properly and adequately.
Okay, so that's a positive note.
Yes.
And maybe Jessica, how can companies navigate the AI Act?
Yes, we have heard that there are some issues, if I may say so. There are some big challenges. We have heard that companies need clarity, guidance, yes, a lot of support. And from the federal government, we have heard this, and we have analyzed what we can do at the moment, while as I said before, the governance structure is being set up. So while we await that, we are looking into two types of measures. One of them is the setting up of an AI help desk, which is actually part of the whole national structure proposal. And this help desk will be an implementation actually of what I said before, the dedicated SME communication channel, but it will be a bit broader. It will be for all stakeholders, all citizens, all companies that will be having questions on the implementation of the AI Act in general. So it should be, because it's a proposal, it should be a one-stop shop for companies and be accessible, easily accessible, and of course make their life easier, hopefully. And a second measure is something that we just started on. We are analyzing and looking also at what other member states are doing in terms of guidelines, concrete guidelines, for instance, a checklist for SMEs to help them comply with the AI Act. We have been doing this also together with our Directorate General SME Policy, who have, of course, the needed expertise on these. And of course, we will also still have to contact if we haven't done so, with the FOTBOSA, to make use, of course, of the whole AI ecosystem that we have in Belgium. So these are two proposals that we have at the moment. They will, of course, also interplay with each other at some time in the future, and we will await the political decisions on it, and certainly on the AI Act help desk.
Well, thank you. And so maybe a question to the three of you. We are actually reaching the end of this panel, of this discussion. So what is the closing message that you want to pass through after this discussion?
Closing message. I maybe want to quickly react to what Jessica is saying, and this is exactly what we need. So I think this is a good message that we're receiving, that from, let's say, the side of the administration, innovation is taken into account, and the fact that there is a lot of help, support needed. This is something we truly, I think, need in Belgium if we want to make this into a success story. So also very happy to support you in this, if you want to hear what we are seeing with companies to help you, let's say, get a sense of this. And then maybe, if I may, on the regulatory sandboxes, I think for us it's a very interesting concept as well. And okay, companies will need support and there will need to collaboration, but what we feel as well is that there should be, if during such a sandbox we notice that there might be something, not wrong, but not functioning within the AI Act, for example. And we feel that this vehicle should also take into account that there's a potential to give feedback, so that in the future, Commission could maybe make some modifications to the AI Act to make it function better in practice.
Sliding, but so basically responding to what Jelle is actually asking, it's one of the purposes basically that we've seen also with the communication that we've got directly with the AI office. They're looking for those exit reports to be able to actually adapt it. So that communication is going to be happening. They really wanted to make it happen, and that's really basically the purpose of the whole endeavor, is in the end to promote innovation while still maintaining some kind of safety standards within the EU. The main point also, that's, well, with what Jessica is saying about the AI help desk, is that a lot of tools are now being built in place in different places to support people that actually need some help. It's not going to be easy. It's also something that people are learning. So when you come to the experts and you ask questions, those experts for the moment don't always have all the answers because they don't really know what questions to expect. So it's going to be an iterative learning process for everybody to move towards let's make it safe, and in a couple of years I'm pretty confident that it will be better along the road.
Thank you. And Jessica?
The last words, yes. Yes, maybe I can end on a more optimistic or overall optimistic note. It's also nice weather outside, so we all should go outside very soon. We have heard now that innovation and regulation go hand in hand together, so we cannot ignore that. And we need and we will support SMEs to embrace the AI Act, if I can say so, to overcome their fears maybe and encourage them to keep innovating. And we think from the federal government that maybe the AI Act help desk will be a first positive step forward in the right direction.
Thank you to all the speakers of today. I'm not now going to turn to the audience online, but also, of course, in the room. If you have any questions, it's the moment. And I don't know if online we do have questions. Otherwise, actually, the time is up. So, except if someone else wants to add anything, I would like to thank then the speakers of the first and second panel, but also the audience for your attention. And I wish you a very great day. Thank you very much.